My name is Eric Niederlehner. I'm a bankruptcy attorney on the Gulf Coast of Florida and Alabama. My main office is in Pensacola, Florida, but I have satellite offices in Mobile, Alabama, Fairhope, Alabama, Fort Walton Beach, Florida, and Panama City, Florida. You're watching the Bankruptcy video blog, and today we're going to talk about adversarial proceedings. These are hearings held in front of the bankruptcy court judge to determine the fidelity of a particular debt or turnover property, these sorts of things. Many people, when they file bankruptcy, think they're going to go in front of a bankruptcy judge. In fact, most filing Chapter 7 never see the judge. They'll see a trustee, but they don't see the actual bankruptcy judge. They would see a bankruptcy judge if there's an adversarial proceeding filed. Federal law protects an individual from creditor harassment when a bankruptcy is filed, and sometimes disputes arise between the trustee, the debtor, or the creditor, or another party, and the case has to go, or the issue has to go in front of the judge to determine the outcome. An adversarial proceeding is this case that's brought before the judge. And it's a separate case, but it's heard by the bankruptcy court when the judge, or when the bankruptcy court has jurisdiction over the matter. Jurisdiction of the bankruptcy court judges is limited to core proceedings, and that's matters that relate to the actual bankruptcy. Matters that don't relate to the bankruptcy, like modifying child support or granting a divorce or something like that, are not core proceedings, and they're not adversarial proceedings, and they're not heard by the bankruptcy court. But common disputes that are adversarial proceedings are cases involving return of money or property, a case to determine the fidelity or priority of a given lien, an objection to the discharge of a debtor's bankruptcy case or revoke of a discharge, an attempt to revoke or prevent confirmation of a Chapter 13 bankruptcy plan, and a case to decide if a debt is eligible for dischargeability in a bankruptcy, such like a student loan or something of that matter, or when an injunction is requested to prevent somebody from selling or getting rid of property or something of that matter. Now, not all disputed matters are related to the bankruptcy case and aren't filed as adversarial proceedings. The bankruptcy rules distinguish between adversarial proceedings and contested matters. The federal rules of bankruptcy procedure state whenever there's an actual dispute other than an adversarial proceeding before the bankruptcy court, the litigation to resolve that dispute is a contested matter. An objection to the proof of claim is an example of a contested matter that's not an adversarial proceeding. Proof of claim is a piece of paper a creditor files in a bankruptcy case saying that they're owed X amount of dollars based on the prior debt that the debtor had with that creditor. Sometimes disputes arise that they're charging a bunch of fees, or they don't own the debt, or it's past the statute of limitations, what have you. Sometimes there's objections to proof of claims, and those are contested matters and not actual adversarial proceedings. To start an adversarial proceeding, the party that wants to file it must file a complaint with the bankruptcy court alleging fraud or debts caused by willful or malicious injury. The issue requires the complaint be filed within 60 days after the first meeting of creditors. The court will issue a summons, schedule a trial date, and hold a hearing, and evidence is offered in that hearing and testimony. An adversarial proceeding does not postpone the debtor's discharge. However, the discharge of the debt at issue may be delayed until the adversarial proceeding is resolved. So if the adversarial proceeding happens after the discharge, or the ruling comes down after the discharge, you may not know if that debt that's subject to the adversarial proceeding is going to be discharged or the debtor will still owe it. So while most people don't see a judge and adversarial proceedings are not filed often, they can happen, they do happen, and it's important that you have proper legal representation to fight those and get the best outcome possible for your case. If you're considering bankruptcy, either Chapter 7 or Chapter 13 bankruptcy, give us a call. My name is Erich Niederlehner of the Law Office of Erich Niederlehner. Our toll-free number is 877-607-2228. And our website is shouldifileforbankruptcy.com. And like I said, you're watching the Bankruptcy video blog. We have offices in Mobile, Fairhope, Pensacola, Fort Walton Beach, and Panama City, so we're here to help you. Thank you for tuning in, and we look forward to hearing from you.